On this episode of Law Weekly, we discuss issues of politics, the inclusion of male women in the process, and much more. My guest is Senior Advocate of Nigeria, Ebola Adegboruwa. We also look at the recent Court of Appeal judgment on Section 8412 of the Electoral Act, plus a recap of some of the trending legal stories. Hello and welcome to the program. I'm Shola Shuyeli. Senior Advocate of Nigeria, Ebola Adegboruwa, is well known for his activism and believes that society must always look for ways to use the law as an instrument to challenge impunity, bad governance, and many other vices. He has very strong views about the conversations that should be shaping the forthcoming 2023 elections and much more.
When you talk about election, it has to do with the opportunity given to the electorate to exercise their mandate to choose their leaders. And this comes once in every 4 years, especially for the case of the president, the governors, and the members of the legislature. And so when you want to go into such social contract, you should talk about what you have brought to the table. What are the things that you want to execute? What are your programs? What are your policies? The conversation should go around the life of the electorate now, and then what you want to do to make it better. And so when you talk about zoning, when you talk about the quality of the individual candidates, then it reduces that conversation to the ordinary talk, which does not really address the interests of the people. So personally, I believe that we know the crisis that is plaguing us in our country, chief of which is insecurity. Every candidate should probably tell us what they want to do that the present government is not doing. The economy is in crisis, unemployment, youth restiveness, inflation. You see the problems we're facing with power supply, lack of infrastructure. Even the railway that we thought was something new is running into some stormy water. So when the electorates come to us, the conversation now should be about what they want to do in the line of the politicians. The conversation should be in line with Section 14 of the Constitution, that the security and welfare of the people should be the primary purpose of government. Unfortunately, that is not what we see now. We hear about the competence of candidates. We hear about issues of loyalty. We hear about issues of consensus, presidential preference. We hear about waiting in the wings to know probably who the president will choose in his own party. And then, of course, in the other dominant parties, we hear about zoning, which shouldn't be the conversation. So it's unfortunate, but that's where we find ourselves.
Let's move on to another issue that has generated serious controversy in recent times, and I'm talking about the high cost of nomination forms by political parties. What, in your view, is the implication of this?
Well, I think when you look at the various fees pegged for those nomination forms, especially the ones decided by the ruling party, it then becomes worrisome. Because this is a party that came into power and has been preaching frugality. It's been preaching that we manage our economy because there is no fund. We're borrowing money to finance the budget. We're paying back loans, even interest, not the real loan. There's crisis the world over, economic crisis. The exchange rate is at its lowest. Factories are closing down. So when you consider that, and then you discover that a political party that is in power has been able to fix the cost of obtaining presidential form alone at 100 million, it then becomes very, if I may use the word, scandalous, in the sense of the kind of message the same government had tried to preach to us on the need for us to reduce our expectations concerning government performance. And then when you go back to Section 121 of the Electoral Act, it's just clear that the priorities of the political parties is not in tune with what the law expects. Maybe we say the highest we'll fix for any presidential campaign should probably not be more than 500 million. But when a person has already paid 100 million for the form, he has to go around the whole country campaigning. He has to buy vehicles. He has to be involved in adverts. He has to be involved in probably patronizing political heavyweights. You probably discover that the political parties have more or less commercialized the system of election, and except somebody who has some kind of vault somewhere, it's difficult to see how people are able to raise such money. So we're waiting to see what will happen to, especially the All Progressive Congress, because the one for the opposition party is just 40 million naira, if I understand. But you see that it seems that the higher the cost of nomination, the more the candidates, as we have now seen, especially in the All Progressive Congress, on the last count, not less than 20 people have been able to pick the nomination form. So they just pick it like WAEC forms, as if you are taking JAMB forms. So you see that the government is then not sending the right message, because what it then shows is that there's money in the economy. The money is only circulating within the hands of those who are in power, those who have access to power, especially the ruling party. So what the APC has been able to show to the people of Nigeria with this nomination form, is that indeed our country is not broke. That indeed there's enough resources to tackle insecurity, there's enough resources to guarantee power supply, there's enough resources to build roads, there's enough resources to give education to our people, there's enough resources to meet the demands of university lecturers, and there's no reason why you should keep our students at home for so long. If the Minister of State for Education, who is in charge of the universities, has himself picked the nomination form at a cost of 100 million naira, then he has no message to preach to lecturers who are only asking for a pittance of that.
But people will argue that politicians are the same across party lines, especially when one considers the way that it defects.
I am sure that it's until we're able to edge out this particular regime. If there's another government that is able to take over from the present ruling party, you hear monumental and scandalous discoveries, as was the case in 2015. You'll be shocked at the level of the kind of profligacy that has gone on in governance. I agree that indeed in Nigeria, the political parties are the same. The chairman of the All Progressive Congress today used to be a member of PDP. The secretary of that political party used to be a member of PDP. So there is no difference really. Because I believe that if PDP should win election today, most members of APC will also defect. So it goes back to the issue of the narrative of what should guide our choice in exercising our votes. Our decisions should be based on the ideologies of the political parties, the programs they are able to sell to the people, and not necessarily the candidates. Unfortunately, we're not any better, because either you vote for PDP or you vote for APC, there's no change. And which is why we thought that by now there should have been a third force. Maybe the activists, the civil societies, maybe the students' organizations, maybe the labor unions should have been able to give Nigerians an alternative from the same narrative of recycling the old politicians. It's for us, civil society organizations, activists, to be able to put pressure on these political parties not to commercialize the nomination forms. Because by doing that, you have excluded a good number of people, for instance, the youth, for instance, the disabled, for instance, the unemployed, for instance, women. And the judgment of the Federal High Court, which has said women should be given a particular percentage in participation in our national life. Every political party should give respect to such a judgment, for instance. And there should be no reason why you should fix the cost of nomination form for beyond 10 million naira, for instance.
But with the criticism trailing what you yourself has called the commercialization of political aspiration to questions about sources of the funds, do you think it's time to put a law in place to check the trend, or should we make the laws on campaign financing more stringent?
I think that generally, the political parties should be given some kind of liberty to determine their affairs. Before now, even in terms of nomination of candidate, the Supreme Court had been able to create that template to say matters like this should be internal affairs of political parties. Their choice of candidates, the way they run their affairs. It's just that maybe we have not matured to the extent of being able to regulate our expectation in terms of the greed of the politicians. But generally, world over, it is the political parties that should have dominion over matters relating to primaries, choice of candidates. And so by the time you begin to make a law to regulate those things, you are removing from those independence. So it should be the responsibility of INEC, for instance, the supervising agency over the political parties, as it's been allowed under the Constitution, to audit the accounts of the political parties, to demand for the number of candidates that have picked their forms, to demand for explanations, for instance, on why those political parties have made a decision in terms of the choice of the amount for candidates to pay for those nomination forms. But unfortunately, INEC seems to be too bothered about matters relating to elections alone and not discharging the other responsibilities given to it by the Constitution to audit the account of the parties and hold them accountable to their finances and their programs.
Let's go back to the court judgment on affirmative action and the need for all political parties to respect such a judgment. How can women best seek to enforce that judgment?
For me, the first stage is to commend all our women for what they are doing, especially those who brought about the idea of filing that case. We commend our women how they were able to put pressure on the National Assembly to revisit those bills, those gender-sensitive bills that were dropped, to commend them. So there is a togetherness, there is an organization, because that's the starting point, that there must be a willpower, there must be a grouping together of the women, and then from there they can then chart a course. I believe that in the course of this campaign, every women organization should liaise with the women leaders of the political parties to ensure that minimum programs are developed for those parties to implement. And now that we have judicial backing for such ambition, women have no reason not to ensure that they demand and insist upon the enforcement of that decision, starting from the political parties, starting from the wards, the state levels, the House of Assemblies, the National Assembly. It doesn't have to be presidency alone. We should get women to be represented sufficiently and adequately in the ESCOs of the governors, in the ESCOs of the parastatals, in the various formations of our national life.
Finally, let's go back to the issue of insecurity, which you alluded to earlier. I want to talk about the bill passed by lawmakers seeking to criminalize payment of ransom by victims of kidnapping in the country. Do you think that this is a necessary piece of legislation?
The philosophy of lawmaking is, first of all, that you must ensure that the law you are making is enforceable, is practicable. I'll just give you a good instance. There's a law against bigamy, that a woman should not be but you can see that in Nigeria, you can hardly get anybody being convicted for such. There's law against dual marriages. You can't enforce those things because you are mixing law with culture, you are mixing law with religion. So when the National Assembly set out to criminalize payment of ransom, it's just like telling a lie against our existence, because the people who feel the crisis, they know what they are facing. And I'm sure that there are legislators who have been kidnapped before, who paid ransom to be freed. There are police officers who are paying ransom to be freed. There are security officers. The terrorists stormed NDA, National Defense Academy, and kidnapped security officers, and they mobilized and paid ransom to free their people. So I think that, for me, there's no need for such a law. What we should do is to encourage the government, to encourage the security agencies to put their acts together, and find a solution to this. I believe that if we are indeed serious and there's no politics behind this issue of insecurity, it is not a means to launder money. If there is a genuine desire to stamp out terrorists, it doesn't take any rocket science to do so. So the National Assembly should not bother themselves about seeking to criminalize payment of ransom. I'm sure in due time, some of them will soon be paying the ransom. It's almost certain. So unless you tackle the real cause of insecurity, you just be speaking to the air.
Welcome back. We move on now to the Court of Appeal judgment on Section 8412 of the Electoral Act, Many commentators agree that the judgment has not laid to rest the controversies surrounding the provision. In fact, depending on who you listen to, lawyers themselves are giving conflicting interpretations on the court judgment. We have a report on this and some reactions. On April 7, a three-member panel of the appeal court led by Justice Rita Pemu granted the People's Democratic Party (PDP) permission to file a suit as an interested party against the March 18 judgment of the Federal High Court, Umuahia, Abia State. The Abia Court, presided over by Justice Evelyn Anyadike, had ordered the Attorney General of the Federation to delete Section 84, subsection 12 of the Electoral Act. Justice Anyadike delivered the judgment in a suit filed by a lawyer and member of Action Alliance, Nduka Edede. Dissatisfied with the decision ordering the deletion of the section, the PDP approached the Court of Appeal, which subsequently granted an accelerated hearing of the suit. The Court of Appeal has now agreed with the PDP and held that the Abia Court lacked the jurisdiction to hear the suit, as the plaintiff lacked the legal standing to have filed the case. The court subsequently set aside the judgment of the Abia Court, and the implication of this is that to the mind of the Court of Appeal, Section 84, subsection 12 will not be deleted, as it remains the law until it is set aside by the Supreme Court.
With due respect to them, we have passed that stage in our jurisprudence. We have said that as a Nigerian, you are entitled. You don't need to have any other locals. The locals you have is that you are a Nigerian. And as a Nigerian, it will get to a point where you might want to contest for an election and you are a public officer. So it will affect you. So the idea to say that the people that brought that action had no locus to have brought that action, I think is bad in law. But you see, the issue of law is that once a court makes a pronouncement, as long as that pronouncement has not been overturned by an appeal, it becomes the law.
The Court of Appeal judgment, in my view, the court was right when it set aside the judgment of the lower court as it relates to the locus of the person who filed the action. Had no locus standing to institute the action.
Even though the live issue was on jurisdiction, the appeal court went a step further to determine the case on its merit. And this is where it gets interesting and perhaps confusing. The appeal court said if it were to decide the case on its merit, Section 84, subsection 12 would be unconstitutional because it is in conflict with Section 42, subsection 1A of the Constitution, which would deny the political appointees their right to participate in the elections. The implication of this is that the Court of Appeal believes that if the suit had been properly filed by a person who had the requisite locus, Section 84, subsection 12 would amount to a bad law on grounds of discrimination.
In my view, I think it is wrong because the section of the Constitution they refer to had no relationship with that section. That actually talked about discrimination on grounds of religion, sex. It has nothing to do with it. The provision is very clear. Political appointees. It's very clear. To be a political appointee is not a natural right. It is not something anybody is being discriminated. Now, even the president has said, oh, political appointees under me who want to run should resign. He has the power to do so because they hold office at his pleasure.
The implication is that now that as it is, the judgment of the Federal High Court has not been overturned on the issue of that if you're a public servant, you ought to resign before taking part in any elective position. That's the situation.
Some people argue that this decision on the merit is an academic exercise. Others fault the reasoning of the court, arguing that Section 42, subsection 1A is not absolute. Make of that what you will, but what is clear for now is that the directive of the president for ministers with political ambitions to resign is in line with the intent of the lawmakers, which seeks to create a level playing field for all candidates at the polls.
We begin with the report that the Federal High Court sitting in Lagos has nullified all sales and disposal of assets made by the Attorney General of the Federation, Abubakar Malami, under the Asset Tracing, Recovery and Management Regulations 2019. The court also nullified the Asset Tracing, Recovery and Management Regulations 2019 for being an invalid statutory instrument. Justice Ambrose Lewis Alogwa made the order in a suit filed by the Incorporated Trustees of the Human and Environmental Development Agenda Resource Center against the AGF. On November 9, 2020, the AGF inaugurated the Interministerial Committee on the Disposal of Assets forfeited to the federal government, but HEDA approached the court to challenge the AGF's power to set up the committee. At the Federal High Court, Abuja, Justice Ahmed Mohammed has adjourned till May the 23rd for parties to file their final written addresses in the suit by the Governor of the Central Bank of Nigeria, Mr. Godwin Emefiele, seeking to enforce his right to participate in the 2023 presidential elections without resigning from office. The court fixed the date after joining the People's Democratic Party and two others who applied to be joined in the suit as interested parties. Also present in court were the Independent National Electoral Commission (INEC) and the Attorney General of the Federation, who were earlier summoned by the court to show cause why the request of the CBN governor to run for the seat of the President of Nigeria should not be granted. Justice Mohammed has, however, warned that he will not entertain any request for extension of time since all parties have agreed on an accelerated hearing of the case. At the Lagos High Court sitting at the Tafawa Balewa Square on Lagos Island, two cases of national interest came up during the week. In the first case, before Justice Sherifat Shunaike, the court listened to the testimonies of two prosecution witnesses in the case of alleged murder and rape of 22-year-old Bamise Ayanwola. An alleged rape victim, Nneka Odezulu, aged 29, told the court that the defendant, Andrew Nice Omenikoron, raped her in his BRT bus at about 8 p.m. on November 25, 2021, after she boarded it along the Lekki-Ajah Expressway. A second witness, a fleet operational manager at the Lagos Bus Services, Kayode Aluko, told the court that the defendant initially fled after the family of the late Bamise Ayanwola reported him. In the second case involving the murder of the chief executive officer of Super TV, Usifu Ataga, a police officer involved in the investigations, DSP Olusegun Bamidele of the State Criminal Investigation Department, Banti, has told Justice Yetunde Adesoya that the key suspect, Chidinma Ojukwu, admitted to procuring a drug called Rofinol, which she administered on the deceased. Rofinol is believed to be a powerful sedative which depresses the central nervous system. In other news, the National Judicial Council (NJC) has issued policy directions on political and election-related cases to head of courts in the country. This is part of concerted efforts to eliminate incidences of issuance of conflicting orders and judgments capable of disrupting the ongoing electioneering process. Under the new direction, heads of courts are to henceforth be held responsible for loopholes in their areas of jurisdictions. The NJC has also recommended 4 to 6 successful candidates for appointments as heads of courts and other judicial officers in Nigeria. And we round off with the report that Justice Mary Odili has retired from the judiciary after attaining the mandatory retirement age of 70. In her valedictory speech read before other judges, lawyers, politicians, family and friends, Justice Odili, who bowed out of office as Justice of the Supreme Court, asked Nigerians to learn from past experiences, especially the Civil War. She also called for an urgent restructuring of the country in order to steer it on the right course.
And that's the program this week. Many thanks for watching. Don't forget that you can catch a repeat of this program or past episodes on our YouTube page. I am Shola Shuyeli. Thank you for watching and see you next week.